Ready, start. Further division bench of this court in the case of State of UP versus Ishwar Chandra Sharma, has observed that double inverted comma in the present case, legislature to their wisdom has used the words double inverted comma other service matters double inverted comma close coupled with the matter relating to promotion crossing of efficiency bar etc full stop. The provisions contained in Rule 5 is comprehensive in nature and it seems to include not only the period during which period the representation is pending but entire period of service in case the pending representation is not decided within the stipulated time provided under the rules. Full stop. In case the provisions contained in Rule 5 is given different meaning, then itself frustrate the very object and purpose. Full stop. The legislature to their wisdom had provided safeguard to the government employees from suffering from abuse of power by the authority for extraneous reason for promotion to higher post, cadre or grade is not affected because of arbitrary use of power. Rule 5 of the said rules also ensures the finality of a controversy and safe the employee from possible abuse of power or manipulation in the matter of promotion. Full stop. It checked the influence of persons having vested interest in delaying the disposal of the representation with regard to adverse entry with ulterior motive. Full stop. Virtually, Rule 5 nullifies an adverse entry in case representation is not decided within the statutory period by friction of law. Full stop. It has seems to be incorporated as a matter of public policy. Full stop double inverted comma close. Thus, the statutory obligation is casted upon the competent authority to communicate the adverse report within 45 days from the date of recording of the report and a certificate to this effect shall be recorded in the report. Full stop. In the present case, admittedly, claimant slash respondent number 1 has been awarded two adverse entries by two housing commissioners on 26 to 2010 and 18/11/2011 respectively, and the same were communicated to the claimant slash respondent number 1 on 6/1/2012, that is beyond the period of 45 days, as such, the same is in contravention to the provisions of Rule 4 of Rules 1995 and the petitioner cannot derive any benefit from the judgment cited on his behalf in the case of Sukhdev Singh on the ground that adverse entries were not communicated to the claimant slash respondent number 1 within reasonable time because in the present case, as per intention of the legislature while enacting the Rule 4 of Rules 1995, statutory obligation is casted upon the competent authority to communicate the adverse report within 45 days from the date of recording of the report. Full stop. So far as the judgment cited by Sri Ratnesh Chandra, learned counsel for the petitioner in support of his contention, namely, Sukhdev Singh supra close is concerned, in the said judgment, Honorable the Apex Court has not taken into consideration the Rule 4 of the Rules, 1995 and has held that every entry in the ACR of a public servant must be communicated to him within a reasonable time, whether it is poor, fair, average, good or very good entry. Full stop.